Most of you are probably aware that the Fourth Amendment protects you against unreasonable searches and seizures. But when are you being searched? And when are you being seized? And what makes them reasonable? In Terry versus Ohio, the Supreme Court said, whenever a police officer accosts an individual and restrains his freedom to walk away, he has seized that person within the meaning of the Fourth Amendment. So when you are stopped by the police, you have been seized and you are in custody, which requires reasonable suspicion. That means for law enforcement to stop you, they must be able to articulate a reasonable suspicion of your participation in a crime, either past or future. Again, from Terry versus Ohio. Under the Fourth Amendment of the United States, a police officer may stop a suspect on the street and frisk him or her without probable cause to arrest if the police officer has a reasonable suspicion that the person has committed, is committing, or is about to commit a crime and has a reasonable belief that the person may be armed and presently dangerous. Does this logic not extend to having to admit that you are armed? If an officer must have reasonable suspicion of a crime to stop you, shouldn't they need a similar reason to ask if you are armed? And since this is a right protected by the Constitution of the United States, shouldn't the state also be required to show reasonable suspicion before demanding you speak? After all, the law enforcement officer who has stopped you is armed and by logic of this case may be presently dangerous to you. Why should a level playing field between citizen and law enforcement be considered a problem?